Good morning, everybody. Welcome to day 15 of the Karen Reed retrial. My name is Debbie. Welcome to my channel. So, today we are having court again. John J. O'Keefe III, nickname JJ or Johnny, born December 8th, 1975, grew up in Braintree, Massachusetts, and graduated from Braintree High School and Northeastern University. He also earned a master's degree in criminal justice from UMass Lowell and had lived in Canton since 2014. O'Keefe was a 16-year veteran of the Boston Police Department. And Karen is at the courthouse, so we are having court today. Yeah, we were a little bit late, Robbie. Hey, girlfriend. Hey, Carla. Hey, Nancy. Judy with her dropping knowledge on us again about Mr. John O'Keefe, which somebody said in Peter's chat that they noticed they weren't calling John Officer O'Keefe. They were calling him Mr. O'Keefe. And somebody else said that they're not allowed to call him Officer O'Keefe, which I find strange. I don't know why. I don't remember hearing that in any of the pretrial hearings, so it must have been something that they talked about and not televised. I'm sorry, strange. um, I have no idea because they said he was a cop. Like the jury knows he's a cop, so I don't get it.
Now open, you may be seated.
So, Mr. Clerk, you say. Why don't I see counsel at sidebar? Of course, we said that. It's self. Say you're not gonna see you. StreamYard, quit telling me to wait. Okay. Yeah, but they know he's a police officer. Yeah, at least we're not missing anything. Now it says I've lost my screen share audio. There's no sound. How do you know that we've lost audio? Every time I say somebody doesn't like me, Jill says, well, they must. Oh, well, StreamYard doesn't want me to put the comments up. I'll be praying for him, Judy. The state so much in the way they do it. I took my LPM board. You have to get a passport photo. Well, not anymore. But when I took my LPM board, you had to get a passport photo of yourself, and it had to be put on the desk. You were in this big giant room full of bathroom. You had to be accompanied by somebody, like one of the proctors of the exam, so they can make sure you weren't like there were like scheduled breaks. There was like a lunch break, like it was an all day thing. The way they do it now, because when I went back to RN school, I got to do it the way they do it now. It was so much better, so much less stressful. You sit at a computer, and the series of questions, like if you get a type of question wrong, they keep giving you those same type of questions. If there are certain types of questions you get right, then they quit giving you those, and they just keep giving you the questions you have a problem in. And when you answer enough right questions, then your test is over, which is so much less stressful. You don't have to sit there and take a whole giant long test if you're doing well. And it was just so much better than sitting in that great big giant room with all these people. Robbie, that would be amazing, but I don't. My stepdaughters have test anxiety. I don't know why I'm not just fast forwarding because we're behind. Um, so they get to like do the thing. They get to go in a separate room.
All right, for the court.
All that stuff. And I honestly, that's why my stepdaughter didn't. Why she failed her first semester of nursing school because of test anxiety. Because I watched her. She like would bring her clinical kits home and show on the ball perfect with all her technique and stuff. But she had trouble testing. When I get frustrated, I play a Lego game and I just walk around just tearing up Legos. Which I've never been to Legoland, but I want to go. Only problem is I'm afraid I'll want to tear down all the Legos everywhere. I'll just be like, oh, cool. Lego smash. We're caught up to live now. Yay. Let's see. Oh, by the way, Colin last night told us why Judge Fleischer is not streaming anymore. It has nothing to do with him not wanting to stream. He wants to stream, but apparently like altering the videos to like put images and stuff on people in the videos, and it's like they're making fun of the attorneys and stuff, and he wanted that to stop. So like he wants to figure out how to stream. It's not the comments, it's not us, it, it's not um dang it, won't show the comments. If you haven't seen the Lego movie, you wouldn't understand it anyway. Oh, Jill just broke me. Jill just broke me. Oh my god. Okay. Anyway, so he wants to be able to stream, but he wants to find a way to do it so nobody can record it and then like use AI to fiddle with it. It's not us, like the way we watch it and make comments and stuff. It's not us. It's not the people that are truly watching it to learn things about court. So he's kind of stream where it can't be recorded and then manipulated. Okay, that was 100% Jill's fault. Jill, that was. Oh, girlfriend, I swear. Now I can't ever go to Legoland because I'll be laughing all the time. I'll be looking over my shoulder. No, but I did snort. Oh. Okay. If you don't know, Craggle in the Lego movie, I guess I need to explain the joke. Mr. Business is the guy that has the giant Lego set, and Craggle is the glue that glues them all together so the kids can't play with them. You guys watch the Lego movie, it's great. Now I got the song in my head. Damn you, Jill! How long is it gonna take the jury to enter? Oh my god. Ugh.
Yay. All persons for the country of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, Council. Good morning again, Ms. Reed. Good morning, jurors. So,
StreamYard always does this at the beginning of the stream. I don't know why. Once it gets going good, it seems to be okay. I mean, it glitches every once in a while, but well, she has Crohn's, and if she has the flu, it might make the Crohn's worse because when I'm sick, I have IBS and I have fibromyalgia. Any stress to my body, any like abnormal stress, like being sick with the flu or just anything, makes the other chronic illnesses flare up. So if she did have the flu, because that Judy and I were talking yesterday that I guess somebody said she had the flu, and there have been a lot of coughing in the courtroom, that could be flaring up her other illnesses. And if she has Crohn's, she might have to go to the bathroom like more than usual. So that could be what's happening. Yeah, that's why there was no court yesterday. Oh, you didn't tell me that part, Carla. Yeah, glad you're okay, Carla. That's scary. That's super, super scary. Okay, well, let's see what Judge Canooney says.
so we took some time now to address issues that we would have otherwise had to do that way. So we it's about and understanding about yesterday. Sometimes during trials they come that are completely avoidable, and I tried to cancel as soon as we could. We wouldn't even have to come.
StreamYard,
So I appreciate that.
on.
I do have to ask you those questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were last here? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation on this case? Yes. Everyone said yes or nodded affirmatively. Did anyone have to hear or read about this case until the other day? Everyone said no or shook. All right, can we have our next witness, please?
May I?
Yes.
Commonwealth seeks to introduce 2 clips. The
Okay.
first clip.
Oh, well, that would probably make the Crohn's go crazy big time. If it's a stomach virus.
This was sort of like a last date.
I'm never breaking up, never that we're in this good or bad, but you're the best person I've ever.
Why did
Commonwealth.
he stopped it right before she said something good? Did you see that? Ugh.
I don't think, I don't see how John would have known about my text with Brian. And I'm not sure if he knew, he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong.
He's stopping it in the middle of a sentence. That's not fair. I hope the defense plays the whole clip when they get up.
All right, Ms. McLaughlin, who is your next witness?
Your Honor, our next witness is a juvenile by the name of Miss Kaylee Furbush.
Oh. We're going to have to watch the fan for the whole thing? Well, I guess we're just going to have to talk amongst ourselves. Well, this sucks. They didn't do this last time. There just was no court, it streamed at all. No audio or video allowed in court per orders of Judge Beverly Canoni. Murder's retrial will resume shortly. Well, what are we going to do while we wait? About the kids today, we're going to have a long wait. I wish I'd known that. We could have waited and done some more Phil Spector. Oh, well, that's good to know. I don't even think they should be asking the kids anything. Because kids don't, if you're going to fight in front of kids, they don't get, the whole picture.
Metropolitan is live from Dedham Max for the Karen Reed trial. We'll be on location talking Karen Reed with a live arguments tonight, 8 Central on Court B, as Sean Holmes faces.
It was an emotional day in court.
With every development, the Diddy sex trafficking trial, live updates on Court TV.
It won't let me take the comment down. I wonder if I'm going to have to cut this part out later. When I was a kid, my parents, they didn't really fight. They bickered, what I call bickering. And that's the way Travis and I do too. It's not like a real fight. But if you're a kid, you're not really, and again, all the time when it's not really a fight. So I don't like putting kids on the stand to say, how was your parents' relationship? I don't know. Because my mom and dad, one time when I was little, they were play fighting. And I thought they were really fighting. And I freaked out because they were play fighting and dad had a glass of water and he went to throw it on my mom and she held her hand up and the glass hit her hand and broke and her hand started bleeding. And I thought they were really having a real fight. And I'm like, my daddy hurt my mommy, and I was freaking out. And so she had to be like, no, we were just playing. It's okay. I'm fine. It's just a little cut. I'm okay. But that scared me. Like, I won't ever forget that because, my daddy hurt my mommy, But so kids, I mean, they're older, but still, kids don't know. Like, why are you going to ask your kids that question? And the Aruba thing, that's what I can do. Like, the kids were there for the Aruba thing, but they don't know what actually happened. The hotel room. Okay, I'm trying to get to my email to get the motions, the two new motions. I Peter read them yesterday. Peter Tragos read them yesterday, and I thought I could have read them yesterday too. We didn't have court, and it completely slipped my mind. If StreamYard will let me, I've got StreamYard up on my other monitor. That's why my head's turned. What is this you sent me this today? Okay, in the email you wrote, Court of Appeals has given Judge Bev 24 hours to correct buffer zone to meet constitutional requirements. But then you sent me this statement about Brennan. What is that? Who is that statement from? In the matter presently before the court, attorney Hank Brennan, during opening statements to the jury, asserted that the jurors would witness video footage in which a witness identified as Karen approached another party, Nuttall, and stated, "I hit him, I hit him, I hit him." However, upon actual presentation and review of the complete available video evidence during the proceedings, no such statement is seen, heard, or otherwise evidenced in the footage. This discrepancy between counsel's assertion and the actual evidentiary record raises significant concerns and may warrant allegations of attorney misconduct. What does that mean, Brady List website? Does that mean he's going to get in trouble? I hope. Number 1, misrepresentation to the tribunal. Rule 3.3 of ABA Model Rules of Professional Conduct. An attorney has a duty of candor toward the tribunal. Knowingly making a false statement of fact or law, or failing to correct a false statement previously made, violates this obligation. If it is found that attorney Brennan knowingly misrepresented the contents of the video, such conduct would fail under this rule. Ooh, I like it. I like it. I like it a lot. Improper argument or misleading the jury, Rule 3.4e. Under the rules governing fairness to opposing parties in counsel, a lawyer shall not assert personal knowledge of facts in issue except when testifying as a witness, nor state a personal opinion as to the justness of a cause, the credibility of a witness, or the guilt or innocence of an accused. If Brennan knowingly claims something that the evidence does not support, it may contribute a violation of this rule. 3. Violation of ethical duties of honesty and integrity, Rule 8.4c. This rule states it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Mischaracterizing evidence in a way likely to influence the jury may fall squarely within this provision. Four, prejudicial conduct affecting the administration of justice. Should it be shown that Brennan's misstatement was calculated or reckless and designed to improperly influence the jury, Such conduct may also be deemed prejudicial to the administration of justice. If it is determined that the claim made by attorney Hank Brennan regarding the content of the video was knowingly false or recklessly made, it would constitute a serious breach of professional ethics. Such conduct could subject the attorney to sanctions, disciplinary proceedings before the state bar, or motions for mistrial or curative instructions. It is essential for the integrity of the legal system that all officers of the court adhere to their duties of truthfulness and fairness, particularly in statements made before a jury. Wow. So he violated 4 rules with his opening statement. Jeez. Good gravy, Marie. Yeah, just because she was driving does not mean that she did it. And she never said she did it. She said, could I have hit him? Oh, wait, that's a defendant's reply. Commonwealth's motion to introduce additional evidence of the nature of the defendant and victim's relationship. The Commonwealth moves to admit testimony through percipient witnesses who observed the defendant and victim's volatile and hostile relationship as it existed at the time of the victim's death. 4 weeks prior to the murder, the defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. Now, they've already decided that this was not going to come in, but the door was open during those text messages. Now, Peter said that Jackson should not have said Aruba, that he should have said something broader that was not specific to the Aruba vacation, but he said Aruba, so that opened the door. So now Hank has done this motion to bring in the Aruba incident, which is a crock of poop, if you ask me. This incident was observed by numerous individuals who will testify to their personal observations of the incident, as well as to statements of the defendant in the immediate aftermath. So I guess he wants to call. Last time they called the friend that he hugged and her sister, which is the mother of his godson. And all it's going to do is make Karen look like a bad person. So all it does is smear the defendant. And I don't think that should be allowed, because obviously they're still together like a whole month later. So he didn't break up with her over it. He never even said he wanted to break up with her over it. They apparently made up. So it shouldn't be considered as like a motive or anything. That's just stupid. Evidence of a defendant's prior bad acts may be admissible to prove opportunity, intent, preparation, plan, knowledge, pattern of operation, or common scheme or course of conduct, as long as the probative value of the evidence is not outweighed by the risk of unfair prejudice. The determination to admit such evidence based on timeline, place, character or probative value is one for the trial judge to make and will be reversed on review only if palpably wrong. Evidence of the Aruba incident was proffered by the defendant through a series of text messages between the defendant and Brian Higgins, thus opening the door for the Commonwealth to rebut the defendant's misleading and inaccurate claims about what had occurred weeks prior in Aruba. This incident in Aruba seems to also be the turning point in the relationship, as the defendant told Brian Higgins that her relationship with the victim was a very effed up situation, as she had observed the victim all over a friend's sister in the lobby of our hotel and accused the victim of having hooked up with another girl while in Aruba. In the January 29th, 2022 voicemails previously entered into evidence, the defendant screams at the victim for apparently effing another girl and repeatedly refers to the victim as a pervert. There has also been evidence that prior to arriving at 34 Fairview Road, there was a reference to a woman the victim used to date. The defendant proffered the entirety of the text message between herself and Brian Higgins, including the defendant's admissions about her feelings toward the victim and the nature of their relationship. The evidence proffered by the defendant also demonstrated a continuing animosity in the weeks and days prior to the victim's death. The jury should be permitted to hear from the witness of this Aruba incident, who will rebut the characterizations made by the defendant to Brian Higgins. Such testimony would be offered through Laura Sullivan, Marietta Sullivan, Aaron O'Keefe, and Juvenile KF. Evidence of a hostile relationship that tends to explain the purpose of a crime is irrelevant to the issue of malice or intent. Bye, Nancy. In a domestic violence homicide, evidence such as Judy said something about him doing a motion about DV. I think it's this one. In a domestic violence homicide, evidence such as prior disputes are relevant to show the volatile nature of the relationship between the defendant and the victim in the weeks and months preceding the murder, and to explain the defendant's intent and state of mind toward the victim. Evidence of domestic dispute at defendant's apartment before killing, including physical contact, was relevant to show volatile nature of defendant's relationship with victim and defendant's intent. Commonwealth v. Da Lin Huang. Commonwealth v. Rentala, evidence of defendant's prior arrest for assault and battery of victim, defendants and victims' restraining orders against each other, and pitting divorce proceedings admissible in homicide prosecution to show motive and hostile relationship. Yeah, but there haven't been any DV arrests in their relationship. So how can you say a fight over him hugging another girl was DV? That's ridiculous. Absolutely ridiculous. An argument is not domestic violence. Commonwealth v. Almeida, evidence of defendant's previous threat to stab his girlfriend to death admissible to show parties' violent relationship. Commonwealth v. Oberly, allowing previous domestic violence incident by defendant against victim to be admitted in prosecution for subsequent domestic violence to show nature of relationship between the two and to show intent, motive, and absence of mistake or accident. Dang, how many cases are you going to cite, Brennan? Commonwealth v. Miller, evidence of domestic violence committed by defendant against his girlfriend, which led to confrontation between defendant and murder victim, properly admitted to show contentious nature of relationship between defendant and victim, which provided motive for killing. Commonwealth v. Bonomi. Evidence that defendant formed an attachment for another may form the basis of an inference that the defendant entertained feelings of hostility towards spouse prior to killing. Moreover, the state of mind exception to the hearsay rule calls for evidence of a murder victim's state of mind as proof of the defendant's motive to kill the victim, when there is also evidence that the defendant was aware of that state of mind at the time of the crime and would be likely to respond to it. Commonwealth v. Qualls, Commonwealth v. Borodine. Evidence of the defendant's prior conduct is permissible and highly probative to show the defendant's state of mind, to show the defendant's motive, to show the defendant's common pattern of behavior toward the victim, in particular as demonstrated by previously admitted evidence that the defendant would become enraged and accuse the victim of cheating on her, and the nature of the defendant and victim's relationship. Massachusetts courts have repeatedly admitted evidence of prior bad acts to demonstrate a hostile relationship between the defendant and the victim because this hostility is relevant to the defendant's motive to harm or kill the victim. Commonwealth v. Fordham. Commonwealth v. Lowe. A murder victim's intent to end a romantic relationship is material to the defendant's motive for killing the victim. Nobody said their relationship was going to end. It should end, but nothing was said that it was going to end. Jeez, Brennan. The admission of such evidence for the purpose of illuminating a pattern or course of conduct by the defendant is proper. Commonwealth v. Chartier. Commonwealth v. Mamoni. Commonwealth v. Scott. The Commonwealth is entitled to present as full a picture as possible of the events surrounding the incident. Commonwealth v. Hernandez, quoting Commonwealth v. Robideau, where the defendant has opened the door, it is especially significant for the jury to understand that it was the defendant who repeatedly refused to accept the victim's desire to terminate the relationship. He never said he wanted to terminate the relationship. The defendants made repeated hostile accusations that the victim was having an affair and that there was an established pattern of hostility occurring in the weeks and days preceding the murder. For all the above-mentioned reasons, prior misconduct and evidence of domestic violence should be admissible. What domestic violence? What domestic violence? What domestic violence, Brennan? Good Lord, man. This one is about, this came about because of the questioning of Yuri, because AJ was asking him questions about the federal investigation, and I guess he was asking him questions that he wouldn't have known the answers to. And Peter said that Bev should deny this, like deny in part, but grant in part, like tell Brennan, we're going to take this on a case, like a question by question basis instead of just blanket question. I mean, like make it like a blanket order. Because you don't know what you don't know. Like, you have to ask, do you know? You can't just say, oh, well, he wouldn't know the answer to that, so I can't ask it. You have to ask, do you know? And then if they don't know, then you don't ask the question. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable, that's in bold type, and italics, in circumstances in which it was reasonable to expect that the police should have conducted such tests followed such procedures or investigated such information is admissible. However, a defendant does not, quote, have an unfettered right to elicit evidence regarding the adequacy of the police investigation. The admissibility of such evidence hinges first and foremost on its relevance, end quote. Now, this is the Bowden defense, and the Bowden defense is when the cops are incompetent. That defense is the cops screwed up the investigation. That's a Bowden defense. And they're using the Bowden defense and a third-party culprit defense. The Bowden defense they mentioned in their opening statements, but they weren't allowed to do the third-party culprit in their opening statements. So now Brennan's trying to like hamstring them with the Bowden defense. And so Peter said that Bev should say, no, this needs to come up on a witness by witness, question by question basis. It shouldn't be like a blanket, you can't ask questions that they don't know the answer to, because you don't know if they don't know the answer to them. And there was something else I was going to say, and I forgot what it was now. Commonwealth v. Moore, Commonwealth v. Bowden, Commonwealth v. Silva Santiago, abrogated, I don't know what that word means, on other grounds by Commonwealth v. Moore. Judge properly exercised discretion to exclude third-party culprit evidence as part of a Bowden defense where defense counsel's proffer did not demonstrate that the probative weight of the Bowden defense exceeded the risk of unfair. Oh, I remember what I was going to say. Okay, so Peter gave an example. He was going to use like real examples from the case, but he didn't. He used a sports example because Peter Tragos is like way into sports. Every time they start sports talking, I'm like, can we not? Because I have no idea what they're talking about. He used the example of a golfer that he likes because he's into golf, and it was a FSU golfer too, so it's Knowles, but whatever. I'm Gators. Go Gators. Okay, so let's say somebody's car gets broken into, and they put somebody on trial for it. And I says that it was this golfer dude that actually broke into the car. So the cops investigate the golfer. But somebody says, no, the golfer was on the 8th hole of whatever golf course at the time of the break into the car. But the cops looked into that. So the cops did what they were supposed to do. So the defendant can't say, but somebody said the golfer guy did it, because the cops looked into that. So it was done correctly. But if the cops get an eyewitness that says that the golfer did it and they don't look into that, then that's the cops' fault for not following up. But if they follow up on that, then they can say, oh, we know for absolute positive sure that that guy didn't do it. Even though there was an eyewitness that said that he did, we know for absolute 100% sure he didn't do it because we followed up on that. So that's the third party culprit is part of a Bowden defense if someone comes to you and says, but no, this other person did it. They didn't do it. This other person did it. And then the cops follow up on that tip. And then the cops find out that, oh no, that person has an alibi. There's no way that other person could have done it. It is the person we have in custody, or it is the person that we thought that did it. Then you don't have a Bowden defense because the cops followed up on that lead and found that it wasn't a credible lead. Did that make sense? Did I make sense? And in this case, the cops didn't do that. They just didn't even investigate the Alberts, even though it happened on their lawn, because for whatever reason, they said it was a car accident. Yep. Well, we know for sure that Lally was last trial, because it was like the entire trial was Lally trying to say they didn't do anything wrong. So it was almost like Lally's whole case wasn't trying Karen Reed. It was trying to exonerate the McCabe's and the Alberts. It was weird. It was bizarre. The whole first trial, I'm like, what is he doing? He's not trying a case. He's defending the Alberts and McCabe's. Yeah, they did. And I don't think they would have stayed together if he hadn't died. I don't think it would have been long before they would have broken up. Unless they had like counseling or something. Cause yeah, there was problems on both sides. She was insecure. She always thought that he was cheating on her. And with the kids, like she said that he wasn't cut out to be a dad, and she never wanted to be a mom. So, I mean, like, why do you even date somebody with kids if you know you're not going to be a mom? And like, if it's if it's like, they have a mom that's alive, it's like you're going to be like a stepmom to the kids. That's different because you're not going to have the kids all the time. But like in that situation, you know that he's raising those kids. Like he has those kids 24/7, right? So if you really don't want to have kids, why date somebody that has kids 24/7? You know what I mean? Like that wasn't going to work out. Although she did say she was close to his niece, but I don't know what he's trying to say. I guess in Brennan's mind, it is. No one has said that she ever hit him in anger. No one ever said it in the last trial, and I've not heard anybody say it in this trial. Yeah, like, who stays mad for a month? If you stay that mad at somebody for a month, you split. You don't stay and spend the night and take the kids for breakfast and take them to school and Brennan just wants a win so bad. Oh, another thing that Peter said was pretty funny. I think somebody asked it in a super chat. Is Lally going to be like, if it's another hung jury, going to be like happy because Brennan couldn't get a jury to convict her either? So Pete was like, yeah, he's probably going to feel pretty good about it. He's probably going to puff out his chest a little bit and be like, haha, Brennan couldn't get him to convict her either. That would be funny. It would be even funnier if he actually gets her off completely. And Lally can go, well, at least I got a hung jury. But I feel sorry for Lally. I really do, because he's just doing his job, and he actually got booed going into the courtroom. Brennan, I don't feel sorry for. Brennan is Snake. Like, he's lied. He broke 4 rules of conduct and should be sanctioned for it because he lied to the jury. And then when AJ got up there and showed that video and tried to figure out where Karen told Nuttall, I hit him, it didn't match up. There's no place where she's at near him where she could have said that the way Nuttall described it. So there's no way. The way he described the time that she was there at him while he was doing what he was doing, you know what I mean? Like the description he gave, it never happened. So it's insane what they're doing to this woman. I cannot wait for the ARCA guys to get on, because they're doing what they did last time plus rebutting the state's reconstructionist. So it's going to be delicious. I can't wait. Okay, where did I leave off? While Bowden preserves a defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Nothing in the Bowden case authorizes a defendant to introduce otherwise inadmissible hearsay. Commonwealth v. Raposa. The defendant's attempt to elicit inadmissible hearsay under the guise of a Bowden defense is improper. The defense has failed to... Well, that's because you didn't call Trooper Proctor. If you had called Trooper Proctor, it wouldn't have been hearsay, you idiot. The defense has failed to establish that certain information, particularly confidential materials provided by the United States Attorney's Office in February 2024, were known to Sergeant Yuri Buchanan, or that in these circumstances it would have been reasonable for police to investigate such information. For example, the federal government's decision to obtain cell phone records of an investigator and civilians does not fall within the parameters of Bowden, especially when there has never been a showing that those cell phone records were material and relevant to the investigation. Under Bowden, it must be reasonable to expect that police should have followed certain procedures or investigated such information to be admissible. The questions repeatedly proffered by the defense are an improper attempt to admit otherwise inadmissible evidence. Evidence admitted pursuant to a Bowden defense is not hearsay because it is not offered to show the truth of the matter asserted. Rather, that the information was provided to police is information that the testifying witness has personal knowledge of, and yet that information was not adequately investigated. Yeah, and Yuri said, I don't know. And they moved on. So, Brennan, such evidence that police failed to investigate leads concerning other suspects may have been known to law enforcement at the time. Bowden does not permit the defendant to ask questions without proper foundation or questions that are replete of unauthenticated, inadmissible hearsay, solely to infect the jury with speculative claims that the defense has continually failed to establish. See, generally, Commonwealth v. Avila. The more wide-ranging the defendant's attack on the police investigation, the broader the Commonwealth's response may be. Well, they didn't do shit, Brennan. I'm sorry, excuse my language. Similarly, if the defense intends to claim that police lost or destroyed evidence, the defense bears the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his or her cause. If the defendant meets that burden, the trial judge must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Given the defense strategy to ask repeated, improper, and argumentative questions, a curative instruction is insufficient. Therefore, the Commonwealth requests a voir dire hearing of Sergeant Buchanan for the court to determine whether the areas of the defendant's proffer of Bowden evidence is admissible before evidence and argument is made to the jury. Didn't they do that? Hey, Terry. Didn't they do that? They did that little voir dire thing the other day. Okay, this is the defendant's answer to that, I think. Defendant's opposition to Commonwealth's motion to preclude inadmissible hearsay under the guise of a Bowden defense. Now comes the defendant, Karen Reed, and files the instant opposition to the Commonwealth's motion to preclude inadmissible hearsay under the guise of a Bowden defense. The Commonwealth seeks to undermine Miss Reed's right to confront her accusers and to cross-examine witnesses, a right conferred both by the Sixth Amendment of the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. Massachusetts Matt, I have trouble with that state. I'm sorry. Or Commonwealth, whatever it is. Massachusetts Rule of Evidence 611B1 gives the right practical effect, allowing questions on cross-examination on any, this is in bold, any matter relevant to any issue in the case, including credibility and matters not elicited during direct examination. The only requirement is that questions are asked on a reasonable and good faith basis, regardless of whether the party intends to offer substantive evidence of the statements at trial. Questions do not need to be based on admissible evidence, though they may be curtailed when a witness makes continual and repeated denials. Other limits to the scope of cross-examination are harassment, prejudice, confusion of the issue, the witness's safety, or interrogation that is repetitive or only marginally relevant. Vague suggestions of racial, ethnic, or religious prejudice without any support are impermissible. Limits, however, do not include instances where the defense seeks to elicit testimony from a witness about the adequacy of police investigation. Such testimony is explicitly protected under Commonwealth v. Bowden and Massachusetts Rule of Evidence 1107A as both relevant and permissible. Testimony elicited in support of Ms. Reed's Bowden defense does not have the effect of harassing the witness or confusing the jury, nor are the questions marginally relevant. Rather, questions on cross-examination about an investigator's knowledge of the very investigation he was conducting is highly relevant. 1. The testimony Ms. Reed seeks to elicit in support of a Bowden defense is inherently not hearsay and is admissible. Defendants have the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. Specifically, Ms. Reed is permitted to offer evidence regarding a third-party culprit whose existence was known to the police, but whose potential involvement was never investigated. In this scenario, the risk of prejudice to the Commonwealth is less because the police are able to explain what they did to determine that the suspect was not guilty of the crime. Whether there are other potential subjects with incentive to direct police attention away from themselves and towards someone else, namely the defendant, is highly relevant in a criminal trial. Commonwealth v. Matai. Finding it improper to prevent a defendant from cross-examining police officers about their knowledge of the criminal records of other potential suspects. Evidence offered in support of a Bowden defense is not hearsay testimony. It is not offered for its truth. Commonwealth v. Rosa Roman, Commonwealth v. Bazanowicz. Because any statement introduced as part of such a defense are not offered for their truth, but to prove that the police did not take reasonable steps to investigate. Those statements are not hearsay. Commonwealth v. Reynolds. The Commonwealth's assertion of the evidence properly was excluded because it constituted inadmissible totem pole hearsay misses the mark. The defendant did not offer the substance of the informant's tip for the truth of the matter asserted. Just because the same testimony, if offered for its truth, would be inadmissible hearsay, does not mean that it must be excluded. In fact, various cases recognize instances where testimony may be offered for purposes of a Bowden defense, but not for a third-party culprit defense. See Silva Santiago, Commonwealth v. Moore. Reynolds. By definition, questions about Buchanan's investigative knowledge are not hearsay. The testimony elicited from these questions go to his knowledge, understanding of the investigation as it was unfolding, not to its inherent truth. The Commonwealth's motion recognizes that questions about an investigator's knowledge under a Bowden defense are not hearsay. However, proceeds to suggest that answers to questions to this effect are inadmissible hearsay. The Commonwealth's motion goes on to accuse the defense of asking repeated, improper, and argumentative questions, and yet does not offer one example of such questions. Were the Commonwealth's motions granted, it would effectively gut Ms. Reed's ability to offer a Bowdoin defense by erroneously classifying the very questions and testimony that compose a Bowdoin defense as hearsay. The Commonwealth is correct that it must be reasonable to expect that police should have followed certain procedures or investigated such information to be admissible. The Commonwealth fails, however, to explain what precisely is unreasonable about the defense, raising alternate suspects that state police chose not to investigate, despite being aware of their potential motives and opportunities to commit the crime Miss Reed is accused of. The Commonwealth states that the defense's questions thus far have been improper, and yet provides not one example of such improper testimony. Because there's not any. Jeez. Ugh. It is true that evidence offered for a Bowdoin defense must be relevant and more probative than unduly prejudicial. Here, the Commonwealth makes the bare suggestion that testimony about Buchanan's knowledge of other potential suspects is irrelevant. However, it is unclear how a key investigator's understanding of the investigation could be anything other than relevant. Further, it is worth noting that all evidence or testimony proffered by one party will be prejudicial to the other. The key question is whether the testimony in question is unfairly prejudicial. What? I don't know what those citations mean. If evidence is relevant to the adequacy of the police investigation, the judge must then determine whether the probative value of the Bowdoin evidence is substantially outweighed by the danger of unfair prejudice. Here it is unclear how such testimony would be unfairly prejudicial to the Commonwealth, particularly where the Commonwealth has the opportunity to rebut any testimony on redirect. 2. The appropriate avenue for the Commonwealth's concern is a robust rebuttal. Further, the Commonwealth asserts no basis in its motion for the claim that voir dire is the appropriate way to address their unsupported claims. The Commonwealth cites Commonwealth v. Avila to suggest that the defense is seeking to elicit what it calls inadmissible hearsay, and to support its request for a voir dire hearing. However, Avila did not address voir dire issues. Commonwealth v. Avila. Rather, it allows for a robust rebuttal by the Commonwealth of a Bowdoin defense via redirect and the introduction of additional evidence. Further, Avila holds that a curative instruction about the purpose of testimony offered for a Bowdoin defense and in rebuttal was an appropriate avenue to address concerns as to how that testimony would be considered by the jury. Effective cross-examination is a critical safeguard of liberty and an invaluable tool for testing the reliability of evidence. And as the Supreme Judicial Court has long recognized, surprise is an important element of effective cross-examination. Here, the Commonwealth seeks to undermine this important right and vitiate Miss Reed's constitutional right to cross-examine a key prosecution witness by seeking an order that Sergeant Buchanan be permitted to preview the questions that will be asked by the defense at a voir dire hearing in advance of his testimony before a jury. This request must be denied. Miss Reed has a right to mount a vigorous defense of the allegations against her. She has a right to confront and cross-examine witnesses, and she may present evidence that police investigation in this case was deficient. Miss Reed respectfully requests that the court deny the Commonwealth's request to deny her constitutional right to confrontation. Okay, so that's all the new motions. And it sounds good to me. I mean, his rebuttal, her answer. Because That, like, why are you gonna tell him what you're gonna ask before you ask it? Like, so he can have time to figure out what to say. Hey, Flash. Come on. And if they had just investigated like they should have, and hey, Rodney, if they had investigated like they should have, maybe they covered up. If something I'm lagging again, I don't know why. If something happened in that house and they covered it up good enough, maybe they could have searched the house and not found anything, and then this wouldn't even be a question if they'd done things right. Hey, Nancy. Possible. Okay, let's see what they're doing in the courtroom. No, they're not back yet. Nothing, Nancy. It's National Cereal Day. Oh, I meant to tell you. I don't remember what day it was. I can't remember if it was Tuesday or Monday. It was. It wasn't Nurses Day because nurses don't get a day. Nurses get a week. It was Nurse Appreciation Day, which I thought was weird because we didn't get a Nurse Appreciation Day. We got Nurses Week. Our boss used to give us like a little something every day. It was fun. But the kids are testifying right now. I was reading super fast because I thought they might be done before I got done reading. No, I guess we just gotta sit here and wait. Because now Court TV is talking about the Diddy case. Oh, they gotta look at the freak off footage? Oh my god. I'm so glad I'm not a juror in that trial. I don't even want to talk about that trial. I don't want to cover that trial. I don't want to do anything with that trial. That's just nasty. Ugh. Ooh, I don't have anything to do with that trial. That's disgusting. Mm-mm-mm. Started dying. I started eating that. What was it called? I forgot the name of it. That protein cereal, Magic Spoon. The Magic Spoon? I think that's what it was called. And at first, I really a toy bacon strip. Okay. I really liked it at first, and then after a while, it just like kind of had no taste. So, what do you think about the tennis shoes? Because, like, some people are saying that it's not the same shoe because it looked like the sole was black. And other people are saying that the sole was white in the courtroom, so it's a different pair of shoes. And Andrea Burkhart, I think, said that it was lighting. It was the way that she was photographed that made the bottom look black. And Aussie Insider did a video on the shoes and said that yes, there are stains on the shoes, so it's not brand new, even though it kind of looks brand new and doesn't look like it was out in the snow all night. Someone noted that it was untied. So, like, why would a shoe be untied? Because if you're used to taking your shoes off when you go into a house, but most people just kick off their shoes without untying it. And then there was the, like, weird mix-up in court that they never explained, because they said that Yuri had the shoe from the hospital, and Trooper Keefe had the shoe that was found at 34 Fairview. But then Yuri read 34 Fairview off the evidence bag, and that was supposed to be the one from the hospital. So I don't know what to make about the shoes. But in somebody's video, I don't remember whose, they said that Nikes have a serial number on them. It's on the label underneath the tongue of the shoe. But that's not going to help if we don't know what the serial number was on his shoes before they found them. So I think it's the same shoes. I don't think they switched shoes. I mean, and even if they did, to what end? I do think they planted the taillight evidence, but because why didn't they find any taillight around his body? I think that the shoes don't matter. But I do think there's other ways that shoe could have come off. And other ways the grass stains could have got on the pocket. I mean, on the jeans, on the butt of the jeans. Both of those could have been done by dragging him. I think the ripped pocket could have been from the dog. There's lots of other explanations for things than what they said. Because how are you going to get a streak of grass stains on you if you just fall back? I mean, I guess if you're pirouetted and thrown 30 feet and you slide on the grass, you would get grass stains. But do you guys really think you pirouetted and flew 30 feet in the air? That's why I liked Magic Spoon, just because it was sweet. Because most things that are high in protein aren't very sweet. I've got this thing, I've talked about it on here before, chocolate flavors, because I'm a chocoholic. Chocolate flavors that are higher in protein are not as sweet. It doesn't feel like you're getting that decadent chocolate taste. You don't feel like you're cheating. Like my Herbalife shakes, like I've got banana pudding and cake batter and pumpkin spice. They're all like, I feel like I'm cheating. Like I don't feel like I'm restricting me at all. Like I love it. But the chocolate ones are like, ugh. I mean, they're not bad, but like I feel like I'm on a diet. I feel like I'm drinking a protein shake. Oh, yeah, I forgot to tell you guys. The Menendez brothers might be getting out on parole. I'm so excited. They are going to have such a... Well, I don't know. I guess because they got, because they were such model prisoners, they got privileges and stuff. So they might know how to use the internet and everything. But imagine their culture shock, right? Like, I was watching a YouTube video yesterday of... Whoa. Is Court back? I was watching a video of somebody on the Las Vegas Strip, and I went to Las Vegas when I was 4. And it is so much different now. I've tried the cinnamon one and another one. I don't remember which one it was, though. I don't know if Court TV is doing a replay of the old trial or if this is current. Because it says witness number 25. And by my count, if you count, Kaylee would be 25.
Begins with a history of fingerprints, biology, morphology. It progresses to supervised casework,
And it's
processing techniques, evidence collection, and culminates in a competency exam for any of the disciplines that.
For the crime scene services section, how are assignments made typically within that unit?
Typically, troopers work on an on-call schedule. They're given advance notice, and they're on call for 24-hour periods. Most often, if a call is received or a request is made for crime scene services during that call period, the trooper assigned responds.
And sort of geographically, as far as the on-call trooper is concerned, how is that sort of divvied up?
So I was assigned to the Maynard Laboratory. The crime scene services section is organized by crime labs. Maynard encompasses a large area, upward of 50 cities and towns. Some of the more northern towns would be Lowell and Billerica, and it goes all the way down to Canton and Stoughton. The trooper on call for that 24-hour period covers that entire region.
Now, sir, were you working with the State Police Crime Scene Services section on February 1st, 2022?
Is this the old trial or
Yes,
the
it
new
was.
trial?
And where were you requested to go on that day?
I was requested to respond to the Canton Police Headquarters.
And approximately what time did you arrive at the Canton Police Department?
Approximately 9 in the morning.
And who did you meet upon your arrival there?
I was met by the requesting officer, Michael Proctor.
And what was the purpose, or what was described to you initially as the purpose of you responding to that location?
The request was made for me to assist in documenting a search warrant that was being executed on a vehicle housed at the police department.
And who do you recall being present during your time at the Canton Police Department and during that search warrant execution?
Trooper Proctor was present. There was a forensic scientist from the crime lab, Maureen Hartnett. There were various members of the Canton Police Department. There were members of the State Police Crash Reconstruction Section, Trooper Joe Paul, to name one. There were members of the Norfolk SPDU as well.
And if you know, in addition to Michael Proctor, how many other members of the Norfolk SPDU were present during the search warrant?
I'm aware of at least 3.
Good.
And what was it that you were asked to document at that location?
Namely, it was Karen Reed's vehicle.
And where was that vehicle located within the Canton Police Department?
It was in the garage bay.
Now, can you describe for the jury the process of your documentation or memorialization of that vehicle that morning?
Yes. Typically, upon arrival, I would consult with the requesting officer to determine the scope of the search warrant. In that case, it was Michael Proctor. He described that the vehicle was being searched for a variety of things, to include biological evidence, communication devices, alcohol containers, receipts, infotainment center data, etc. He asked me to document the vehicle with digital photographs. I then consulted with the forensic scientist who was present as well to determine the order in which the vehicle would be documented and processed. I began by documenting the vehicle's exterior with photographs prior to any manipulation or movement. and then proceeded to document the interior and its contents.
Now, any items that were seized during the execution of that search warrant, how were they photographed prior to being seized?
They're photographed in place prior to being moved.
Now, what kind of instruments or tools do you use typically while photographing items for crime scene services?
Main piece of equipment we would use is a digital camera. We wear protective equipment, namely gloves and a mask typically, often a scale, so that the images can be calibrated to true size upon examination later. Sometimes placards or ruler tape be placed on items of interest or items that will be collected.
Now, on this occasion, you mentioned Maureen Hartnett from the crime lab was present there as well.
That's correct, sir.
And what did you observe her doing as far as any sort of documentation with relation to certain things or items or areas of the vehicle?
My recollection is that she was chiefly concerned with the exterior of the vehicle, namely the rear right corner, and she was looking for DNA and trace evidence, I believe.
And as far as, was there any delineation that you saw her place on the vehicle with respect to certain areas of the vehicle?
Yes, she marked various locations on the vehicle with ruler tape.
And is that something that you would photograph both prior to and afterward when she would place those stickers or labels on the vehicle?
The area would be documented during my overall photographs prior to her placing any placards or ruler tape. And then once those cards are placed, they would be photographed again.
Now, in addition to the photographs, what else did you do with respect to the vehicle?
I was also asked to process the front right passenger compartment of the vehicle for friction ridge impressions.
Now, what is a friction ridge impression?
A friction ridge impression is it's a replica or an impression of the friction ridge skin on the hands or the feet. Friction ridge skin is an evolutionary adaptation on human beings that allow for better grasp of objects. What makes it unique and significant to policing is that that friction ridge skin has unique patterns. They're formed through ridges and furrows or hills and valleys, and they're unique to every individual. In the hundreds of years that fingerprints have been studied, no two individuals have ever been determined to have the same fingerprints. Analysts are trained to examine these patterns, more importantly, the individual ridge events, and conduct examinations that can lead to identifications or exclusions.
Now, just briefly, can you describe for the jury that process of how you do that?
I would document the vehicle with photographs first, and then determine what medium would be used to process the vehicle. In this case, white fingerprint powder was selected. The particular area processed was relatively small. It was the front passenger compartment, interior and exterior. I focused on surfaces that were more conducive to friction ridge impressions. Certain surfaces are far more conducive than others. Typically, non-porous surfaces like glass, polished metal, dash surfaces are better for impressions, more likely to yield impressions than porous surfaces, which is items like paper or unfinished wood. The area was processed with white fingerprint powder, examined, and no impressions of value were determined to be present.
Now, just briefly, Trooper Clark, when you say no impressions of value were determined, can you explain to the jury a little more, expound upon what that means?
Analysts are trained to determine during the analysis phase if an impression is of value for comparison. What that means is whether or not the impression, if any, has enough quantitative and qualitative detail where it could be compared to a known impression or exemplar, and defining this case regulations.
Now, upon that initial
view road in Canton and take overall photographs of a scene.
And when you say overall photographs, can you describe to the jury what your understanding of that term is?
Overall photographs are essentially just like they sound. They're not examination level photographs. They're general area photographs. This particular case, it was an outdoor scene. I was directed where to focus my attention, and I took a series of photographs of that area.
Now, did anyone go with you there?
Not that I recall.
And when you say your area, your attention focus.
Upon my at that address where a significant amount of snow had been partially cleared away near a flagpole, he asked that I take overall photographs of that area, given the lighting was preferable, and to focus on the front of the residence, that cleared area, and the street around it.
And Trooper Clark, what do you recall in reference to the snow accumulation on the area of the lawn near the flagpole at 34 Fairview Road on that date of February 1st?
My recollection is that there was a significant amount of snow present. Snow banks were apparent from what I presume to be plowing. There was an area that did appear to be cleared and heavily trodden by footwear and tires. Still, even in that area, there was a significant amount of snow with certain spots of grass showing.
Now, while you were there, sir, did you or anyone else do any sort of excavation of that front lawn area?
No.
Now, following that, where did you go? And
I had finished my assignment with 34 Fairview and I was asked to return. I believe the forensic scientist was continuing to process the vehicle. At that time, I would re-encounter her and determine if there was any additional photographs required.
now, in addition to the photographs that you took initially at the Canton Police Department, what else did you memorialize with reference to the vehicle that day?
They took general photographs of the vehicle, the contents. At one point, a bag was presented to me with evidence by one of the Canton officers.
Let me ask it this way, sir. At some point, you mentioned there was a reconstruction trooper who was present at the Canton Police Department, correct?
That's correct.
And so what, if anything, did you document with respect to that reconstruction trooper outside of the Canton Police Department?
Trooper Joe Paul asked while I was there to document a series of brake and acceleration tests with digital video that he was performing with the same vehicle. I was also asked to take photographs. It was activated as they performed some tests.
Your Honor, may I approach?
Yes.
Sergeant Clark, showing you a disc. Do you recognize that?
Yes,
And what do you recognize that to be?
this is the crime scene photos.
And what's contained on that disc, is that a fair and accurate portrayal of what you observed both inside and outside the Canton Police Department with respect to Ms. Reed's vehicle, as well as the scene at 34 Fairview on February 1st?
I presume it is.
Your Honor, Commonwealth seek to introduce in the minutes the next exhibit.
I'm assuming that that's all that's on the disc, and if that's the case, then we have no objection.
You've seen it.
I haven't seen that particular disc. We have received the photos in discovery. I'm not concerned about that.
All right, that'll come in.
Thank you, Your Honor.
Exhibit 133.
Your Honor, may I have one moment?
Yes.
Your Honor, with the court's permission, if I could just publish a few of those photos for the jury.
Okay.
I'm sorry, Your Honor. May I approach the witness
Yes.
just briefly? Your Honor, presenting me with three photographs. Do you recognize what's depicted in each of those three photographs?
Yes, I do.
And what do you recognize depicted in each of those three photographs in general?
I would describe these as mid-range and a close-up photograph of the vehicle's dash area.
And Your Honor, separately, may I Commonwealth to seek to introduce and admit as the next three exhibits.
All right, I'd like to do it as one exhibit.
A, B, C?
Please, yes.
Exhibits 134A through 134C.
Thank you.
And my apologies, Your Honor. With the court's permission, may I now publish some of those photos?
Yes.
Thank you. Ms. Gilman, if I could have photograph 2616. And Ms. Gilman, if I could ask you to zoom in on the steering wheel just above the L for the Lexus sign. And Sergeant Clark, do you see what's depicted up on the screen?
Yes, I do.
And from this photograph, just above the steering wheel on the right-hand side, what do you observe there?
Vehicle's odometer reading?
And is that what the odometer read as far as when you took this photograph outside of the Canton Police Station on February 1st?
Yes, it is.
And Ms. Gilman, if I could have 2617. And again, Ms. Gilman, if you could just zoom in a little on the center of that photograph. And again, Sergeant, if you could describe for the jury what we're looking at in this photograph.
Vehicle's display screen, the center console, with the what I would describe as the backup warning system activated as the vehicle approaches a pedestrian.
And lastly, Ms. Gilman, the next photograph, which is 2618. And again, Sergeant, what are we looking at in this photograph?
More or less the same as the last photograph, sir.
Closer image than the prior photograph, is that correct?
That's correct.
Thank you. Ms. Gilman, you can take that down. Thank you, sir. I have nothing further for this witness, Your Honor.
All right. Mr. Giannetti?
Thank you, Your Honor. Good morning, Trooper.
Good morning, sir.
Your earliest involvement in this case was on February 1st of 2022.
That's correct.
You ended up, and by the way, at that time, you were a trooper assigned to the crime scene services section,
That's correct.
and that was in which town in Massachusetts?
Where I was assigned, sir?
Yes,
Maynard.
Maynard, okay. About a year later, you actually joined the Norfolk CPAC unit or the Norfolk Detectives Unit, correct?
That's correct.
And when you joined the Norfolk CPAC unit, Lieutenant Brian Tully was the supervisor of that unit, was he not?
Yes, he was.
You are still with that unit, correct?
That's correct.
So you've been there for approximately 2 years, a little bit more than 2 years.
That's correct.
And so you were there when Lieutenant Tully was removed as the supervisor of that unit, correct?
That's sustained, and folks should to disregard that.
Now, if I could request an instruction.
Jurors, pay no attention to that question or answer. That is not properly before you with this witness.
Is Lieutenant Tully still the supervisor of that unit?
Yes.
I'm going to see you at sidebar for just a minute, please.
Okay, so going back to February 1st of 2022, you learned that Michael Proctor had called your unit, resulting in your involvement in this case on that date, correct?
That's right.
And Michael Proctor had requested that you go to the Canton Police Station.
That's correct.
At the time, were you aware that the Canton Police Station, or the Canton Police Department, I should say, had a conflict of interest with this investigation?
Objection.
Rephrase it. Rephrase.
Well, were you aware when you were called out on this case, that John O'Keefe had been found mortally wounded on Brian Albert's lawn?
It was advisable.
Okay. And you were you advised of the fact that Brian Albert's brother was a Canton police detective?
I did not know that.
All right. Still, it was the Canton Police Station and not a state police barracks where Michael Proctor instructed you to go, correct?
That's right.
Was he there before you, or did you arrive there before him?
He was there before me.
When you got there, where did you see Michael Proctor within the Canton Police Department?
Inside the garage bay.
And is that also called a sally port?
Yes.
And when you got there, was Michael Proctor the one to direct you to the Lexus SUV?
Yes.
And when you got there on February 1st, that was the first time that you laid eyes on that vehicle, correct?
Yes, it is.
There was no other investigator from the State Police Detectives Unit or the CPAC unit there with the Lexus SUV except for Michael Proctor, correct?
There were other investigators from the Norfolk District Attorney's Office present that morning.
In any case, you had no personal knowledge prior to your arrival of how long Michael Proctor had been with that SUV before you got there, correct?
That's right.
You have no personal knowledge about whether anyone was monitoring Michael Proctor while he was near the vehicle before you got there.
That's correct.
And before you got there, you had no idea how much access Michael Proctor had to that vehicle, right?
Correct.
Your assignment was to take photographs and to process the passenger's compartment in particular for fingerprints.
Correct.
And you did that.
Yes, I did.
Bless you. About a year and a half after that, on July 18th of 2023, you participated in this investigation again, did you not?
Yes, I did.
And that was because, in part, you had now joined the Norfolk CPAC unit, correct?
Correct.
And you participated in an interview of Colin Albert at the Norfolk DA's office, right?
That's right.
You knew at the time that Colin Albert was the nephew of the homeowner, Brian Albert?
Objection.
I'll allow that. Did you know that at the time?
Could you rephrase the question?
Sure. At the time that you were called in for this interview and told that you would be participating in an interview of Colin Albert, you knew that he was Brian Albert's nephew, correct?
I was advised that prior to the interview, yes.
You conducted that interview along with Michael Proctor, correct?
Correct.
At the time, Michael Proctor was a state trooper in that unit, correct?
Yes, he was.
And you knew he was also the lead investigator on the case, correct?
He was the case officer, yes.
At the time of that interview on July 18th, before you began questioning of Colin Albert, had Michael Proctor revealed to you his connections with the Albert family?
Sustained.
Will you approach?
Go on to the next area. Let's see if I can come back.
Did Michael Proctor reveal to you that he and Kevin Albert had socialized together by drinking alcohol in his cruises?
Sustained injures. I'm going to ask you to strike that question. Disregard.
I need to be heard at sidebar.
I will hear you.
a good time to take our morning recess. We'll see you in about 20 minutes. And Sandra, you can just follow out.
All right, please.
Was he done with Cross? I totally missed everything he said. Yeah, I won't ever get off mine. They started me when I first got diagnosed. They put me on Prozac, and Prozac made me bipolar. I had a friend that was a social worker, and I used to be a member of the community theater, and we had had a rehearsal for a play, and then we had a party at my house afterwards. Can't remember if it was a rehearsal or a performance. Anyway, afterwards, I was, just my normal self, goofing around, being normal, and just chatty, talking a mile a minute, just like more than my usual. Like I was manic. And then halfway through the party, I was in the corner, not talking to anybody, almost in tears. I was a mess. And my friend, because he recognized the symptoms because he was a social worker, he came over and sat down next to me and he's like, "What's going on? Earlier you were like the life of the party and now you're just sitting over here in the corner and avoiding everybody." I was like, "Man, I don't know. I have no idea what's going on. I don't know what's happening at all." So he talked to me for a little bit, and I think this was so long ago. I don't even remember. I think we kind of came to the conclusion that it might be from my medicine and a therapist. Now, I loved my therapist, he was great, but the psychiatrist was a quack because he put me on Zoloft, which I love. I'm on Zoloft to this day, and I will never ever get off of the Zoloft. He put me on Zoloft, but he's like, when you start to feel better, you can wean yourself off of it. If you have clinical depression, you have a chemical imbalance in your brain. You're going to be on antidepressants the rest of your life. And I've talked about this before. It's just like I have diabetes too. I have a chemical imbalance in my pancreas. And it's not, well, I mean, that can get better by losing weight, but it's a chemical imbalance in my pancreas. And nobody thinks bad about a diabetic because their pancreas doesn't work right. I know, Nancy, right? Like he was a quack. Like wean yourself off your meds when you feel better. I feel better because I'm on the medicine. So I tried to wean myself off. I did it twice before I realized this isn't gonna work. So I ended up on it. Now I'm on 2 pills a day, so 200 milligrams a day. Because it doesn't come in that one pill in that dose. I don't know why. So I'm on the highest dose you can be on, but it works. And I still do get depressed sometimes, even when I'm on it. But that's usually like, because it's more like other things make me depressed. Like I'm bored because I haven't been able to get out and do what I want to do, or because I don't have enough money to do something I want to do, or, like situational type depression, the kind of depression everybody has, you know what I mean? But, yeah, mental illness isn't fun, y'all. It's like, and I'm blessed that I don't have the kind of mental illness that make people want to self-medicate with drugs and it makes them crazy and then they get, they break the law. I don't have that kind of mental illness and I feel very blessed that I don't. But it's on my mom's side of the family. Most of my medical problems are from my mother's side of the family. Um, when I get it really bad, all I can do is just lay in bed and cry. I become totally frozen, I guess, is the best way to explain it, where I just can't do anything. My cousin, she can't do anything, but she says she doesn't feel. And like, I'm not a cutter or anything like that. I've heard about cutters that they say they don't feel anything, so they want to cut themselves. My cousin doesn't cut herself, but she says she gets that where she doesn't feel anything. I don't understand that, because I don't understand not feeling. I feel awful. I feel sad. I feel despair. I feel hopeless. I mean, it's horrible. It's just like, you just don't want to live anymore. It's awful. It's an awful, awful feeling. I just can't describe it. I wouldn't wish it on my worst enemy. It's horrible. So there have been 2 times in my life that I have felt like I just don't want to be here anymore. And I've never tried to do it. Thank God I've never tried to do it. But I've wanted to. So it's not fun. And from what I've heard about jails is that they do not treat mental health. So were you to go to a hospital and get things straightened out and then go to jail, everything they just did to straighten you out, then you'd go to jail and get all screwed up again. So going to prison would not help. And 9 times out of 10, the person is off their meds, and the kind of people that break the law when they're off their meds, they're the ones that have hallucinations and voices telling them to do stuff. So they're not in their right mind. They don't even realize they're breaking the law. They might think they're on the moon. Like, who knows what they're thinking? Like, there's a antidepressant called Lexapro. She was just evil. She was just evil. She was wanting to do stuff. She had like a boyfriend. She had a burner phone. What kid has a burner phone? Hers, see, now this is where she's different from Gypsy Rose Blanchard and the Menendez brothers. She wanted to smoke pot and hang out with a boy that her mom didn't approve of. She had a burner phone. She just wanted to be a bad kid. She didn't do it because she was being abused. She wanted to be a bad kid. Yeah, she deserves all the time they can give her. No, I didn't want him to get charged. His mom was an abusive biatch. I hated her. But you also have to, I'm seeing it through someone who was abused. My mother wanted me to be a child forever. I was not taught how to do laundry, how to cook. I was not taught how to do anything for myself. I moved out of my dad's house because my dad was sick. My mom died when I was 21. I moved in with my dad because my dad, after my mom died, my dad sold the house that we lived in and he built his own house on like the property that his dad left him when his dad died. And dad made the house just very small because he thought it was just going to be him living here. This is the house I live in now, by the way. So my room was so small that I had to walk between my bed and my dresser sideways because that's how small my room was. So I told my dad, I said, Dad, if I'm going to stay here with you, you're going to have to make my room bigger. So he made my room larger because he didn't want me to move out. And then my mom died in 90, and then in 95 he almost died. He was in the hospital for 12 weeks. So I became his caregiver. And then when he got better and started dating again and going on trips and doing his thing, I moved out. So I was like 33 when I moved out of my dad's house. And I moved into an apartment, and there were mothballs in the closet in the apartment. And I hate the smell of mothballs. Now I'm 33 years old. I called my dad to ask permission to throw away the mothballs. My dad said, Debbie, it's your apartment. You can do anything you want. So that was my mindset. At 33, I felt like I had to ask permission to throw away a box of mothballs. That is how bad my mother messed up my psyche. So don't tell me that a controlling parent doesn't do any damage. And I'm sorry. If you disagree with me about the Menendez brothers, we will just have to agree to disagree. But that man screwed up those boys so much. I feel like 30 years is plenty punishment for them. They will never kill anybody else ever again. Carly Gregg is a totally different thing. Totally different. She wanted to be a little brat and do whatever she wanted and smoke pot and hang out with boys her mother didn't approve of. Her mother was a good mother and cared about her and wanted her to do what was right. The Menendez brothers were abused by their father. Their mother let it happen, and he abused other boys too. He was a producer in Hollywood. There's been members of the group Menudo that have come forward and said that he sexually abused them as well. He even made his oldest son abuse his younger son. So don't tell me. Okay, I'm done. We'll just have to agree to disagree. No, you're not wrong. Yes, if you do something wrong, you should pay the consequences. But they have. It's been 30 years. They've paid their consequences. No, you weren't raised wrong. You were raised right. You were raised right. And I'm glad. I am glad that people don't understand what they went through. Believe me, I am glad. But when you're 33 years old and you have to call your daddy to ask permission to throw something away in your own apartment, that's twisted. That's what that woman did to my head. So that's why I feel the way I do about the Menendez brothers. I am by no means saying that it's okay to kill your parents and get away with it. That is not what I'm saying at all. And I'm not mad, y'all. I'm not mad. I know I sound mad. I'm not mad. I'm remembering my own abuse and how it felt. I didn't have physical abuse. There wasn't any minor physical abuse, like getting popped in the mouth or something, but minor compared to what they suffered. Very, very, very minor. So I'm not mad. I'm just, they've been punished enough. Their whole life has been punishment. They went through things that nobody should have to go through. And then they got put in prison. They told family members, and family members knew what was going on, and nobody would help them. Likewise with Colin Griffith. Colin Griffith asked for help. He told the cops. He told the parole officer. He told everybody he could tell and didn't get help. So That's all I'm saying, is that these kids that are abused and can't get help, we need a better system in place for abused children. And the Menendez brothers, their dad had spies everywhere. They lived in LA. Lyle went to college in Princeton, in New Jersey. His dad knew everything he did almost before he did it, because he had spies on him all the time. So they couldn't run away. They couldn't do anything. Their dad knew every move they made 24/7. Like, there was even a girlfriend that his parents didn't like, that I forgot how they did it, but they made him break up with her somehow. There is a lot of nuance. There is a lot of nuance. And they did plan it, and they should be punished. But I don't think that life in prison is the punishment for abused children. Now, I think Gypsy Rose Blanchard, I think her ass should still be in jail, because she married some poor guy in order to have a place to live when she got out of prison, and now she's divorced from him. And I think she used that guy when she had a perfectly great place to go, because her dad would have taken her in, no problem. But I guess she didn't want to go live with her dad. So she decided to marry some schmuck, and she fooled him. And now she's divorcing him and with some other guy. And I think I heard somewhere she's pregnant now, or at least says she's pregnant now. Well, yeah, but do you think someone is going to get on the stand and tell the whole world those things were done to them? The first trial was televised. I don't think they were lying. And because they were youthful offenders, that law wasn't in effect when they were charged. But because they were youthful offenders, they should have been eligible for parole anyways. Now, Carly Gregg, I think should have been eligible for parole at one point. I don't think minors that are tried as adults, I think they should be eligible for parole. I don't agree. How old was Carly Gregg? 15? I don't agree with locking up a 15-year-old child for the rest of their life. I think that they deserve to have parole. I believe in second chances. Now, if it's a serial killer or something like that, or a serial rapist or whatever, yeah. But a child?
All right, so I'll see counsel at sidebar.
Put us back in session, maybe?
Well, that's true too, Jill. Yeah, that's true. Oh, did she have the baby already? I don't know. After she got married and then almost immediately divorced the guy, I was like, okay, I'm done being on her side on this. Because I was on her side. Like, I was actually happy for her that she got out so quick. Well, how long was she in there? Like 10 years? I love you all. I'm not mad. We're just having a discussion. I got a little, it hits too close to home, guys, okay? It just hits too close to home. I loved my mother. I would have never done what they did to my mother. I loved her very, very much. I think had she not died when I was 21, my life would have turned out a lot differently. That's all I'm saying. I think they've been punished enough. So I'm not mad at y'all. I love y'all. It hits too close to home. It's a sore spot with me, okay? Rod Farrell. That sounds familiar. The girl. Oh. Okay. I hope I didn't make anybody mad. I hope nobody's mad at me. Like I said, it hits close to home. That one does. It hits too close to home. And that's probably why you think I got mad at you that day in Alita's chat, Flash. Well, and you also got to remember they were rich kids too, so they didn't know how to live on nothing. Well, you still don't. What do you mean you didn't have the best temper back then? I love you. I love you, Flash. I'm sorry, Carla. I'm not mad. I'm not. I just think they've suffered enough. I was teasing you. You tease me all the time. Stop it.
Counsel,
Rise for the jury.
exhibit II for ID.
Thank you.
I know. And I said that. I did. I said it hits close to home. I know. And you've known me long enough to know that I react before I think. And then later I apologize. That's the way I am. And you guys love me anyway.
Orders of session, please be seated.
All right, may we have Sergeant Clark, please?
Oh, good. He's not done with cross. I missed the whole thing. Okay. Jill, what have you sent me now? I gotta mute my mic.
proceed, Ron?
Yes.
Okay,
Sir,
I
when
will
you
watch that
went
later.
with Michael Proctor to interview Colin Albert, you knew that
Jill just sent me videos about child serial killers.
the case originated on January 29th of 2022,
I was aware of that.
and the date that you conducted that interview was July 18th of 2023.
That's correct.
Did you ever ask Michael Proctor why he waited a year and a half to interview Colin Albert?
I did not.
Once that interview was concluded, one of the two of you had to write a report to document what Colin Albert had told you, correct?
That's correct.
And Michael Proctor, as the lead investigator, was the one to write the report, correct?
Michael Proctor wrote that report.
You did not write it.
Correct.
He chose the language to use in that report, correct?
Correct.
And you weren't standing over him while he was typing it up, correct?
Correct.
And he wrote that report to his supervisor without running every word by you, correct?
That's correct.
Did you ever review that report to check whether it was accurate?
Not before it was published.
You were called to photograph evidence on February 1st. Were you ever asked to go to 34 Fairview Road on February 8th to photograph and document evidence supposedly found on that day?
No, I was not.
Were you ever asked to go to 34 Fairview Road to document any evidence on February 10th?
No, I wasn't.
How about February 11th?
No, sir.
And then on February 18th, nearly 3 weeks after January 29th, did anybody contact you to ask you to come out and photograph and document evidence that was supposedly found 3 weeks later?
Ask it differently, Ms.
Yes.
Giannetti.
Were you called out to 34 Fairview Road on February 18th of 2022 to photograph and document anything?
February 1st was the only date I was called to 34 Fairview, sir.
So the answer to my question is no, correct?
That's correct.
Thank you, sir.
Is there any follow-up, Mr. Lally?
No redirection.
Sorry?
No redirection.
Okay. All right. You're all set.
Thank you, Your Honor. Thank you, folks.
Next witness, please.
Yes, Your Honor. The Commonwealth called Evan Brent to the stand.
Okay.
Who is that?
Excuse me.
You solemnly swear the evidence you give the court that your case narrative is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning.
Good morning.
All right, go right ahead, Mr. Lally.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please state your name and spell your last name for the jury?
My name is Evan Brent, B-R-E-N-T.
And what do you do for work, sir?
I work for the Massachusetts State Police
And how long have you been a trooper with the Massachusetts State Police?
for just under 8 years.
And in what capacity do you currently work with the State Police?
Currently, I am a sergeant and I'm assigned to the Leominster Barracks.
Now, going back to when you initially joined the State Police, did you undergo any training?
Yes, I did.
And could you please describe for the jury, generally speaking, what that training consisted of?
I went to the State Police Academy in New Braintree. I attended the 83rd Recruit Training Troop from August 2017 until January of 2018. And I learned about different topics that you would expect to learn about at an academy, such as criminal law and procedure and motor vehicle law, to name a few.
Now, when you joined the State Police, where were you initially assigned?
I was initially assigned to the Holden Barracks.
And how long were you at that barracks?
for about 3 or 4 months.
And where did you go from there?
I went to the Charlton Barracks
And how long were you in Charlton?
for a little over a year.
And then following Charlton, where did you go from there?
I went to a unit called Crime Scene Services.
Now, what specialized training did you receive in relation to that work with the Crime Scene Services Section unit?
New members assigned to crime scene undergo a progressive training program that consists of completing a series of modules, each of which has assigned reading, a written test for each one. It moves on to assisting in the lab and then eventually assisting in the field. There's additional assigned readings, classroom instruction, and it concludes with a series of competency tests that must be passed before you are assigned your own casework.
Now, when you're working for the Crime Scene Services Section, how are assignments or how are you assigned to a particular case or investigation?
As cases come in, if you're on call, you would own that case if it's your call day, if something comes into the lab or something you need to respond to.
And how long do those on-call periods typically last for?
Typically, when I was there in Maynard, it was 24 hours. So you would own a day starting at 7 in the morning, and it would go all the way until 7 the next morning.
Now, how big of an area does that particular unit, the Crime Scene Services Section, how big of an area does it cover?
The Maynard lab covers somewhere between, I think, 50 and 55 different municipalities.
Now, sir, were you working with the State Police Crime Scene Services? Where were you requested to go on that day?
I was requested to respond to an address in Canton.
And do you recall what that address was?
It was 34 Fairview.
And approximately what time did you arrive at that location on Fairview Road?
It was about 9:45 in the morning.
And who did you meet upon your arrival there?
I met with several members of the State Police Detective Unit for Norfolk County.
And do you recall specifically who those members of the State Police Detective Unit were?
Yes, there was Lieutenant Tully, Sergeant Buchanan, Trooper Proctor, Trooper DeChico, and Trooper Moore.
And when you arrived there, what were you asked to document on that occasion?
There was a search effort digging through some snowbanks that they were looking for some items. They wanted me to document it with photography.
Now, during that search effort, were items located and recovered?
Yes.
Now, can you describe for the jury the process of item recovery that you observed there on that day?
So once an item was excavated, I would be alerted. I would come over, I would document the item in its place, and then one of the detectives would use a gloved hand, and that item would be bagged and documented on the bag.
Was that the same with respect to each item that was photographed by you and then bagged by the State Police Detective Unit?
Yes.
Now, if I could just ask you if you could expound a little. When you say excavated, what do you mean by that? What did you see being done that day?
They were digging with shovels.
And as far as the recovered, do you recall where they were in relation to the snow pile and the ground itself?
Some were on top of the snow. So there was some significant snow melt. I think that day it was raining out and it was much warmer than it was the previous 3 days. So some had been revealed by this melted snow, so they were on top. Others were under a foot and a half of snow.
Now, what kind of instruments or tools do you use in addition to your camera when you're photographing items?
So items of interest would be documented with a scale, so that way it would show how big the item is.
And why is it that you use a scale as far as photographs are concerned when it comes to certain items?
Because some of the photos, you wouldn't be able to tell how big the item is or proportionally what it looks like. So it has the scales, just a little ruler that shows exactly how big the item is.
Now, sir, upon your completion of documenting recovery of items at Fairview Road, were you asked to go anywhere else?
Yes, I was.
And where were you asked to go?
I was asked to go to and address 1 Meadows Road.
And who went with you there?
Trooper Proctor.
And once there, what were you asked to document or memorialize at that secondary location of 1 Meadows Ave?
There was a vehicle in the driveway that he wanted me to document.
And was that a Chevrolet Traverse? Is that correct?
Yes.
And were you asked to document anything else with respect to the home adjacent to that driveway?
There was a camera up above the garage that he had pointed out, so I just documented that as well.
Thank you. Your Honor, may I approach?
Yes.
You're showing you a disc. Do you recognize that?
Yes.
So what do you recognize that to be?
It's a disc of crime scene photos.
And the photos on that disc, are those the photos that you took at each of those respective locations on February 3rd, both 34 Fairview and 1 Meadows Ave?
Yes.
And what's contained on that disc and those photos, is that a fair and accurate portrayal of what you observed at each of those respective locations that day?
Yes, it is.
Your Honor, Commonwealth seek to introduce the minutes of the next exhibit.
And same caveat, as long as that's all that's on that disc, we have no objection.
Okay. Coming in.
Exhibit 135.
And Your Honor, may I approach the witness again?
Yes.
Sir, I'm handing you a series of 7 photographs. Do you recognize generally what's depicted in those 7 photographs?
Yes.
And in the first 5 of those photographs, is that essentially taking photographs as you walk around the Chevrolet Traverse in the driveway that day?
Yes, that is correct.
And the last 2 were of the garage doors at 1 Meadows Ave, is that correct?
Yes, sir.
Your Honor, Commonwealth seek to introduce and admit the next exhibits.
No objection.
Exhibit 136.
And Your Honor, with the court's permission, may I publish those photographs in relatively short fashion with the jury?
Sure.
Ms. Gilman, if I could have photograph 7749.
Why did they take pictures of his car?
And Trooper, just briefly, what are we looking at in this photograph?
The front entrance to that address, 1 Meadows.
Ms. Gilman, 7752. And Trooper, same question. What are we looking at here?
That was the vehicle in question.
And if you could, Trooper, just describe sort of perspective-wise what portion of the vehicle we're looking at in this photograph.
So we are looking at an angle view of a Chevy Traverse, the back of the vehicle, and part of the driver's side.
And Ms. Gilman, 7759.
Of the rear of the vehicle and the passenger side.
And Ms. Gilman, 7769. And again, Trooper, what portion of the vehicle in this photograph?
This is the front of the vehicle.
And Ms. Gilman, 7771. Again, Trooper, what are we looking at in this photograph?
An angle view of the front of the vehicle and the driver's side.
And Ms. Gilman, if I could have 7777. And again, Trooper, what are we looking at in this photograph?
This is the driver's side rear quarter panel.
Scale 7791.
Not yet, Flash.
Now, you also took photographs of the garage doors at 1 Meadows Ave, is that correct?
Yes, sir.
Okay, and how many garage doors did you observe there that day?
Two garage doors.
And which of the two is this?
This is going to be the right garage door.
And Ms. Gilman, if I could have 7795. And which of the two garage doors is this, Trooper?
This will be the left garage door.
Thank you very much. Ms. Gilman, thank you very much. You can take those down. Now, Trooper Brent, from your observations of those photographs and your observations personally, visually on scene February 3rd at 1 Meadows Ave, what damage did you observe to the garage doors at that residence?
I did not observe any damage to them.
And again, both from your view of those photographs and your in-person visual observations of the Chevy Traverse from all angles on that date of February 3rd, what damage did you observe to that Chevy Traverse?
I observed no visible damage.
Thank you, sir. No further questions, Your Honor.
All right. Any questions, Mr. Yannetti?
Yes, Your Honor, thank you.
So they're saying his car must have had damage because her taillight got broken on his car. They're trying to prove she didn't break it on his car.
Good morning, Trooper.
Morning, sir.
I hate you so much.
To be clear, the Chevy Traverse that you photographed at 1 Meadows, you did so, and you realized at the time that was days prior to the incident in question, which was January 29th of 2022?
5 days after, not prior.
Did I say prior?
You did.
Thank you for correcting me because you're right. You were photographing it 5 days after January 29th, correct?
Yes, sir.
And it's fair to say, sir, that your earliest involvement in the case was February 3rd of 2022, correct?
Yes, sir.
So you don't know, and you didn't know at the time who had access to that Traverse during those 5 days, correct?
That is correct.
Now, as of February 3rd of 2022, you, I believe, testified you were part of the crime scene services section of the Massachusetts State Police, correct?
Yes, sir.
You met former Trooper Michael Proctor on February 3rd at 34 Fairview Road in...
Okay, he doesn't know who had possession of that car in those 5 days, but I guarantee you, if the owner of the car just died, nobody's priority was to take that car to a body shop to get a dent taken out. I mean, I get what he's saying, but, you know, like, that's kind of common sense that nobody would have taken that to get the dent taken out of the car.
You can't?
Yes, I did.
At the time, did you know you were at the home of a Boston police officer named Brian Albert?
I did not.
And February 3rd was the first and only time that you responded to 34 Fairview Road, correct?
That is correct.
With regard to anything that you saw on the lawn or on the snow that day, you have no personal knowledge as to how any of those items got there, correct?
I do not.
And 5 days after January 29th, you had no personal knowledge at the time of who had access to that front lawn during those 5 days, correct?
That is correct.
You had no information that a guard had ever been posted near that lawn?
Not that I'm aware of.
And when you got there, there was no crime scene tape, correct?
No, there was not.
There was no tent?
No.
Other than the police officers standing there on February 3rd, the lawn was open to anyone who wanted to look at it, just like any other lawn on the street, right?
I'm unaware of that. I don't know.
Now, in terms of your actions that day in documenting the scene with photographs, you did not write a report on what you saw and what you photographed, correct?
I took notes of what I saw and what I photographed.
Michael Proctor was the one to write the report in which he reported that you were the photographer on scene, correct?
I don't know what Michael Proctor did for a report, so I can't testify to that.
Okay. But you didn't write a report.
I wrote a report of what I did, showing up at the scene and taking photos and then submitting those photos to the Norfolk County Detectives Unit.
You knew at the time that Michael Proctor was the lead investigator on the case, correct?
Yes, I did.
And with regard to other dates in February, on February 8th of 2022, were you asked to go back to 34 Fairview Road to document and photograph anything found on that day?
I do not believe so, no.
What about February 10th?
No.
February 11th?
Again, my only involvement was on February 3rd.
So that means that on February 18th, nearly 3 weeks after January 29th, you were not asked to go back to 34 Fairview to document or photograph anything on the lawn that day, correct?
Correct.
I have nothing further, sir. Thank you.
Any questions, Mr. Lally?
Very briefly.
Okay.
Just for clarity, Trooper Brent, you did write a report in relation to your response documentation on February 3rd, 2022, correct?
That is correct.
And you mentioned that you also took notes, is that correct?
That is correct.
And what did those notes entail?
It detailed several items that were collected, my response time, and who else was there on scene.
Now, when you were there on scene, as far as 34 Fairview on February 3rd, what did you observe as far as these? You mentioned that the weather had gotten warmer, some snow had melted. What did you observe specifically as far as the snow accumulation on that front lawn area in the area of the flagpole of 34 Fairview?
Objection beyond the scope.
Sustain. Sustain.
As these items, again, when they were recovered, several of these items were under how much snow?
I would estimate about, there was one particular item that was about a foot and a half under the snow.
Nothing further.
Nothing on that.
All right. All right, Trooper, you are all set, sir. Thank you. Who is the Commonwealth's next witness?
Your Honor, the Commonwealth called Brian Gallerani to the stand.
Okay.
I think there's a lot of Bryans in Massachusetts.
Your Honor, as this witness is approaching, can I just move into evidence clips 19 and 20 that were previously played for the jury?
Yeah.
Thank you.
I didn't realize Brian was such a popular name.
Exhibit 137.
Thank you.
You solemnly swear the evidence given to the court during the case now and here true, the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
Good afternoon.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself?
Gallerani.
And what do you do for work, sir?
I'm currently employed as a sergeant for the Needham Police Department.
And how long in total have you been a member of the Needham Police Department?
19 years.
And how long have you held the rank of sergeant?
2 years. It'll be 2 years in July.
Now, prior to holding the rank of sergeant with the Needham Police Department, what did you do before that at the Needham Police?
I was a detective for 8 years.
Now, over the course of your work as a detective with the Needham Police Department, what training have you received in regard to collection of biological samples?
I've been certified by the Mass State Police since 2015 in collecting DNA.
Now, can you explain just briefly to the jury sort of what that process of certification entailed? Sort of how did you become certified?
Excuse me. So specifically, I was certified in DNA buccal swab, which is the process of obtaining cells suitable for comparison, DNA comparison, by swabbing a person's cheek cells and gums.
And that certification that you received, is that up to date at this point?
It is.
Now, at some point on January 16th of 2024, did you have occasion to collect buccal swabs or samples in relation to this case?
I did.
And before I get to that, just briefly, as far as with your work as a Needham police detective and or sergeant, you had no involvement with any investigation either by the Canton Police or the state police in relation to any incident in the town of Canton, correct?
Correct.
Now, with respect to that date of January 16th, where did you go?
I went to Norfolk County DA's office in Canton.
And who did you meet with, or who did you collect samples from on that occasion?
I collected samples from Trooper Proctor and Sergeant Buchanan.
And again, briefly, can you explain to the jury the process of that collection of samples from Sergeant Buchanan and Trooper Proctor?
Mm-hmm. So I swabbed the inside of their mouths with a cotton swab. I let it air dry, put it in the kit, sealed it, and photographed it.
And then following your collection, what did you do with those collections once you had them?
I brought that back to the Needham Police Department and entered it into the evidence locker.
And as far as that collection process that you were describing, did you do that in conformity with the training and the certification that you referenced earlier?
I did.
Now, with reference to those items, at some point were you informed that those items were to be transferred or transported to a Bodie Technology Lab in Lorton, Virginia?
Yes.
And were there any specific instructions as far as shipping that you received from the lab in reference to those items?
There were.
And did you comply with those instructions as far as how those items were shipped from the Needham Police Department to the Bodie Lab in Virginia?
Yes.
I have nothing further. Thank you.
Any questions from the defense?
Very briefly, Judge. Good morning, sir.
Good morning.
Were you ever asked to do any buccal swabs of Chief Berkowitz of the Canton Police Department?
I'll allow that.
No.
Were you ever asked to do any buccal swabs of Detective Kevin Albert of the Canton Police Department?
No.
Were you ever asked to do any buccal swabs of Lieutenant Brian Tully of the Massachusetts State Police?
No.
Thank you. I have nothing further.
Anything, Mr. Lally?
No, Your Honor.
All right. Thank you very much, Sergeant. You're all set.
Thank you.
I missed this whole witness.
Next witness for the Commonwealth.
I missed this whole witness.
Commonwealth calls Maureen Hartnett.
Bill had to go outside. Did I miss anything important? Dadgum.
Follow me, ma'am.
I did hear that Yannetti said you
You
called
solemnly swear the evidence
correctly.
you give the court and jury in the case now hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good afternoon.
Good afternoon.
You can sit or stand wherever you're comfortable. Just please keep your voice up, okay?
Yes.
Whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and offer the spelling of your last name?
My name is Maureen Hartnett, Hartnett.
Could you tell us where you presently work?
I work at the Massachusetts State Police Crime Laboratory.
Before you began working at the Massachusetts State Police Crime Laboratory, did you receive any education, any further schooling after high school?
Yes, I did.
Could you share that with us?
I have a bachelor's degree in biology from Bridgewater State University and a master's degree in forensic science from the University of New Haven.
After you graduated with your master's, Did you begin working at the crime laboratory or did you work somewhere else before?
I began working at the Massachusetts State Police Crime Laboratory.
How long have you worked at the Massachusetts State Police Crime Laboratory for?
I've worked there in total approximately 9 years.
Can you give us a basic understanding of how the crime laboratory you work at is broken down, the different departments and what you do?
There are various units within the laboratory. There is the criminalistics unit, which is the unit I work for, the DNA unit, the Office of Alcohol Testing, the Arson and Trace unit, and each of those units is comprised of civilian workers. And there's also portions of the laboratory that are made up of sworn or troopers that work for crime scene services section as well as the firearms identification section.
Would you consider your role a civilian worker or are you a Massachusetts State Police trooper?
I'm a civilian worker.
You mentioned that one of the departments that you work in is the criminalist unit.
The criminalistics unit.
Could you give us a little more detail about what the unit does?
In the criminalistics unit, we examine items of evidence for the possible presence of biological fluids. We conduct trace identification, damage analysis, as well as gunshot residue collections on evidence.
Do different employees do different things in that unit, or do all the employees, are they trained to conduct all of those different type of testing?
There are specific types of analysis that only certain members of the unit will conduct based on the fact that those types of analysis are not requested very often.
Is the unit broken down by level of experience? Are there different roles within the unit based on experience?
Yes, there are.
Could you explain that, how it's broken down, the structure of it for us?
Generally, a training analyst will be a forensic scientist 1, which means they're in training and they're not performing any type of independent casework. Once an analyst is authorized to perform independent casework, they are then a forensic scientist 2. And that above them would be their supervisors, which are forensic scientists 3. And that is specific to the unit. And then as the chain of command goes up, there are additional levels as well.
Do you have a particular level that you've achieved?
Currently, I'm a forensic scientist 2 in the criminalistics unit and crime scene response unit.
In addition to your education and your master's degree, do you receive any specific training when you enter the unit?
Yes, every analyst will receive generally the same training when they enter the unit. It is written in our protocol, so it is standardized, and that is completed once they enter the unit. It takes approximately 9 to 12 months to complete that training.
Is there any ongoing training involved when you work in the criminals unit?
Yes, as a part of our accreditation, we also receive ongoing education yearly.
You mentioned accreditation. Can you briefly tell the jury what that means as it relates to the unit and the lab?
Accreditation is a voluntary quality assurance program that the laboratory is a part of. And basically their role is to ensure that our protocols, our procedures, our equipment, and our personnel are held to a certain level based in the scientific community.
In your role, do you do all of your testing at the office or in the lab?
As part of the crime scene response unit, I will respond to crime scenes and I will perform some testing and collection at crime scenes as well.
How long have you been involved in the crime scene response unit?
I've been involved with the crime scene response unit the same amount of time I've been in the criminalistics unit, which is approximately a total of 9 years.
As part of crime scene response, do you actively go to an ongoing developing scene, or do you arrive somewhere after the event?
It depends on the circumstances. Oftentimes we are called out to a scene directly after the incident takes place. There are times when we also will examine additional items or additional scenes after the fact.
How many scenes have you responded to as far as crime scene response where you were the person who was in charge?
I would say approximately 300.
When you are asked to or assigned to go to a scene, a crime scene, whether it's active or whether it's later in time, do you make an assessment when you get there, or is there a plan developed before you leave your office and get to the scene?
I'm sorry, can you be more specific?
Sure. How do you decide what you're going to do before you get there?
Generally, when I arrive on scene, I get a brief description of what they think may have occurred. Of course. I will take an overall sketch and diagram of the scene, and I also take some notes of the scene before I perform any type of testing or collection.
When you arrive at a scene and you start engaging in an analysis and determine whether you want to do testing, are you allowed to use your own independent judgment?
Yes, I use my training and experience to determine what items I would like to test and what items I would like to collect.
Is there ever any input by whatever law enforcement team or officer is at the response scene?
Yes, there is.
You mentioned that you've been to a number of crime scene responses. I want to ask you specifically about a response on February 2nd, 2022. Do you remember that?
May I check the date on that?
With the court's permission, please.
Yes, you can.
Thank you. So I responded to a crime scene on February 1st of 2022.
My apologies. Where did you go on February 1st, 2022?
I was dispatched to the Canton Police Station in their garage area.
When you went to the Canton Police Department, did anybody else from your lab go with you?
There was a crime scene services trooper that also responded at the same time, but there was no additional crime scene responder from my unit that responded.
Did you arrive at the Canton Police Department?
Yes, I did.
Is there a garage that you were directed to?
Yes, I was.
When you arrived at the garage, which sometimes may be referred to as a Sally Port area, were there any other people there when you arrived?
There were Massachusetts State Police troopers as well as some Canton police officers.
Did you know who they were?
I did know who the Massachusetts State Police trooper was, yes.
Was Michael was trooper police department officers? Do you know Lieutenant Gallagher?
Yes, I did have an interaction with Lieutenant Gallagher as well.
When you got there, did you have a chance to look at an item?
Yes.
Tell us what your focus was on. What type of item?
I was asked to examine a black Lexus SUV.
And was there a black Lexus SUV?
Yes.
As you were observing and making, analyzing the item, did you see whether anybody was taking photographs?
Yes.
When there's a person taking photographs, do you ever have any input or direct them, or do they do that totally independent of you?
After they're done doing what they're required to do, I will ask them to take specific photographs because I do not perform that function at a crime scene.
When you first arrived, did you have a chance to walk around the vehicle?
Yes, I did.
Did you observe the vehicle from standing behind it, looking at the back of it?
Yes, I did.
May I approach, Your Honor?
Yes.
I'm handing you a document. Do you recognize that?
Yes, I do.
And what is it?
This is the rear of the black Lexus SUV.
Does that photograph, does it appear to be substantially accurate to what you saw that day?
Yes, it is.
Is it a fair and accurate depiction of what you saw?
Yes.
May I approach again?
Yes.
I'll move this into evidence, please.
Okay.
No objection, Your Honor.
Exhibit 138.
Show P145.
Okay.
Ms. Hartnett, is that what you saw when you arrived?
Yes, it is.
Did anything stand out to you when you first looked at the back of that Lexus?
I noticed there was some damage to the rear passenger area of the vehicle.
You can take that down, please. Did you have a chance to walk around and look at the vehicle from the driver's side of the vehicle, the left side?
Yes.
I'm showing you a photograph. Do you recognize what's in that photograph?
Yes.
What is it?
This is the driver's side of the Lexus.
Did the Lexus appear to you?
Yes.
An accurate depiction?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
Okay, thank you. Exhibit 139.
With the court's permission, I'd ask to show the jury P-144.
Okay.
Could you describe what you saw, ma'am?
Yes. So this is the driver's side of the black Lexus.
Thank you. You can take that down. Did you get a closer look from the right side of the Lexus to pay detail or attention to what you described from the back view that stood out to you?
Are you referring to the damaged area?
I am.
Yes. So I did take notes of that area and as well as had additional photographs taken of that area.
May I approach, Your Honor?
Yes.
I'm showing you a photograph. Do you recognize it?
Yes.
What is it?
This is a close-up photograph of the rear passenger side tail light area.
Does that photo depict what you saw that day?
Yes, it does.
Is it a fair and accurate depiction?
Yes.
With the court's permission, I'd like to use that as an exhibit.
No objection, Your Honor.
Thank you.
Let's protect his
May I
voice.
show it to the jury, Your Honor?
Yes.
P-161, please. Could you describe what you saw?
Yes, that is the rear passenger tail light of the vehicle.
Is that how it appeared when you first walked in that day?
Yes, it is.
You can take that down. Thank you. When you examine an item like a car, do you take any type of efforts to protect from contamination?
Yes.
What do you do?
Before processing or touching any item of evidence, I'll put on gloves. I use disposable instruments whenever possible, or if I need to use reusable instruments, I will spray them with a 10% bleach solution prior to use. I also change gloves often while I'm examining a vehicle and keep my notes and my pens that I'm writing my notes with. I don't put on gloves when I touch those, and then when I go back to examine the vehicle, I will then re-put on gloves to protect the evidence.
If you see something of note, something that stands out to you, do you have any way of marking the item?
Yes, I take diagrams at the scene and note on my close-up photographs, and I will request the crime scene services trooper who's assigned to crime scene to take those photographs.
Do you ever put any type of markers on the item itself?
Yes, generally I will mark the items with either a letter or a number so that I'm able to refer back to them both in my notes, and I'm able to refer to them when I look at the photos.
When you mark different items or observations that you make, do you give a specific number to each item for to memorialize it?
Yes, I either use a lettering system or a numbering system.
And how do you memorialize it? Do you put it in writing?
Yes.
What do you do?
On my diagram, I will refer to something, for example, as letter A, and then I'll also mark that item using a marker on the item of evidence with the same letter so that I can connect and associate the photograph with my notes and anything that I collect as well.
In addition to the broken taillight that we just looked at, did you make observation of any other things? And I'm just asking generally, not asking you to specify.
Yes.
Were there other things that stood out to you?
Yes.
Did you take any swabs, to see if there was any biological evidence?
Yes, I did.
Where did you take swabs from as far as trace for blood?
I screened for blood on various areas of the undercarriage of the vehicle.
And what was the results?
Those were negative.
What does negative mean?
It means that there was no blood present in that area, or if there was, it was below the level of detection of our test.
Did you make any observations where you saw items or marks of interest?
Yes.
I want to ask you about any observations you made of the back bumper. Was there anything significant that you saw relative to the back bumper of that vehicle?
Yes.
And share with us what you saw.
There were scratches on the bumper as well as apparent pieces of glass on the bumper.
When you saw what you believe to be pieces of glass on the back bumper, what is the process you follow?
I gave those an identifying letter. I noted those items in my diagram, and then I eventually collected those items.
How do you collect them?
I would have used either disposable tweezers or tweezers that were cleaned with a 10% bleach solution.
After you collect the items, for example, glass on the back bumper, what do you do with that?
In that moment or later on?
Take us through from the moment you have it till the end.
So I would put those pieces of glass into a glassine envelope, which are then packaged in a larger manila envelope. They are sealed and dated and initialed with my dates and initials. Eventually, when I return to the lab, those pieces are given an item number and then secured in our cold room.
Is each piece of evidence given a separate item number?
Yes.
As far as the entire case, your entire response, not the separate pieces of evidence you may find, is it assigned a particular number or a case number?
Yes, each case will get a larger case number, and then each item within that case gets an individual item number, so that item can be tracked throughout the lab.
Do you remember from your memory what the case number of this investigation as far as your response was?
Yes.
Could you share that with us?
The case number assigned to this in the laboratory information system was 22-2184.
I want to go back to the glass in the bumper. May I approach, Your Honor?
Yes.
I'm showing you a photograph. Do you recognize what's in that photograph?
Yes, I do.
Is that a fair and accurate depiction of what you saw that day?
Yes.
And could you generally describe what you see?
This is a close-up photograph of the apparent glass on the bumper of the vehicle.
Can we listen to evidence, please?
No objection, Your Honor.
141.
Court's permission, I'd like to show P167 to the jury.
Okay.
There are 2 pointers in front of you. Would you mind pointing out for the jury what stood out to you? And Ms. Gilman, could we get a little bit of a close-up on that bumper, please?
So I can see one of the, it's a little difficult to see, but I do. It'd be better if I use this one.
Could you? Do you mind?
A piece here is a larger apparent piece of glass. I think that was the largest one that I saw.
And those 2 white stickers, could you tell us what those are?
This sticker, this sticker here is marking where the apparent pieces of glass are.
Is there another sticker above, or is that?
I'm not sure. If you could close up, I'm not sure what that is. Yes, so that is another sticker, and next to that sticker are additional pieces of glass.
Those items to the right of that picture, are those pieces of glass?
Yes, I would say that's an apparent piece of glass here, and this one.
Could we just go down to the bottom part again, please? Thank you, Ms. Gilman. You can take that down. Did you collect what appeared to be items of glass?
Yes, I did.
Were they assigned a particular number?
Yes.
Do you know that number offhand?
I would have to refer to my notes.
With the court's permission?
Yes.
Thank you.
Please.
Those items were given the item number 3-3.
Did you focus on the right rear side of the vehicle beyond the broken taillight?
Yes.
Did you notice any damage, any scratches to the right quarter panel or the right side of that Lexus?
Yes, I did. I noticed some scratches as well as a dent in the rear door in that same area.
Let's start with the scratches first. When you notice scratches, is there a way you marked them?
Yes, I would have given them a letter.
And did you do that?
Yes.
May I approach, Your Honor?
Yes.
Showing you a photograph. Do you recognize that photograph?
Yes, I do.
Do you recognize what's in that photograph?
Yes.
What does it depict?
It is a close-up photograph of one of the scratches on the right rear area of the vehicle.
Is that a fair and accurate representation of what you saw that day?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
All right.
Exhibit 142.
With the court's permission, I'd like to show the jury P-172.
Okay.
Could we close up just a little more, Ms. Gilman? Thank you. Starting at the bottom, what is that, ma'am?
That is a close-up of the scratches that I noted in that area.
Could you zoom out again, please, Ms. Gilman? Is that on the back bumper or the right quarter panel?
I believe it's on the right bumper. It's a little difficult to make out in that photo.
Could you zoom in again and move up just a little higher, Ms. Gilman? Thank you. You have another sticker on the top?
Yes, I do.
Do you know what that is?
Yes, I do.
What is that?
That is an apparent hair that I noted in that area.
So that doesn't designate a scratch. That's something entirely separate and different.
That's something different, correct?
We'll get to that later. I just want to point out that it's not a scratch. Now, you mentioned that you saw a scratch. Was it a singular scratch or a number of scratches? Could you zoom in, please, Ms. Gilman?
It was a couple of scratches.
Is there a number you designate if it's not a physical item, if it's something like a scratch, or the designations just for actual physical items?
I use the designation for both observations as well as physical items.
Would there be a number for the scratches?
Yes. Well, there's a letter. Yes.
Do you know what that letter is?
Yes, I believe it's D.
D. Okay, thank you. Take that down, please, Ms. Gilman. May I approach, Your Honor?
Yes.
I'm showing you another photograph. Do you recognize what's in that photograph?
Yes.
What is it?
That is damage that I noted on the rear trunk door of the vehicle.
Is that a fair and accurate depiction of what you saw?
Yes.
When you say damage, what type of damage did you notice?
There was some scratches as well as a dent.
I'd like to move this into evidence.
No objection, Your Honor.
Exhibit 143.
With the court's permission, I'd like to show the jury P-176. Can we zoom in just a little bit more, please? You told us that you saw both dent and scratches. Starting with the scratches with the pointer on the TV to your right, could you show us where you saw further scratches?
So the scratches are up above, and then down here there's chipped paint and a dent.
And where is the dent in relation to the scratches?
Just below it.
Could we zoom in a little more if we could, Ms. Gilman, please? Can you see in this photograph the dent that you saw?
Yes, I was referring to this area here as a dent in my observations.
Thank you. You can take that down, please. You mentioned a hair. I'm going to ask you some questions. How many pieces of hair did you find attached to that Lexus?
I found one apparent piece of hair on the Lexus.
Was there a designation number for the hair that you found?
Yes.
Do you remember what that number is?
I used the letter A for that particular item.
Did you say letter A, ma'am?
Yes, correct.
May I approach, Your Honor?
Yes.
I'm going to show you two photographs. You take a look at the first photograph, please. You recognize that picture?
Yes, I do.
And what's in that photograph?
This is a photograph of the apparent piece of hair I noted on the rear area.
Is that a fair and accurate depiction of what you saw that day?
Yes.
Turn to the second photograph, please. Do you recognize what's in that photograph?
Yes, I do.
What is it?
This is an additional photo of the apparent hair on the vehicle.
Both photographs of the same piece of hair?
Yes.
And the second photograph, is that a fair and accurate depiction of what you saw?
Yes.
I'd like to move these two photographs into evidence, please.
No objection, Your Honor.
Okay, is A and B, please.
144A and 144B.
With the court's permission, I'd like to show P173 to the jury. If you could get in as close as possible, Ms. Gilman. Do you recognize what's in that photograph?
Yes, I do.
And can you share with us what you saw?
This is a close-up photo of the apparent piece of hair on the rear of the vehicle.
What did you do when you saw that, what you thought to be a piece of hair?
I marked it with the tape. I designated it as letter A, and then I asked the crime scene services trooper to take a photograph of it.
Did you try to preserve it in any way?
Yes, I did.
Tell us how you preserved that apparent piece of hair.
I collected that hair with either disposable tweezers or tweezers that had been bleached with a 10% bleach solution. I put them in a glassine envelope and then put them in a larger manila envelope. In a larger manila envelope.
What happens to that larger manila envelope?
It is returned back to the lab. It is submitted under the same case number and given its own individual item number.
Did you bring it personally back to the lab?
Yes, I did.
When you brought it back to the lab, do you remember where you brought it when you got back to the lab?
After it was entered into the computer system, I then sealed it, I initialed and dated it, and then I would transfer it to the crime scene response holding area in our cold storage room.
When you pass it along, is it to protect it in evidence, or is it for a purpose of further testing?
At that point, it's just to store it in evidence, and then it will make its way into whatever unit needs the piece of evidence first.
And you did all that with that piece of evidence?
Yes, I did.
I'd like to show the second photograph that you identified. I believe it's P165.
Isn't there some question last time, Judy, about the hair being in a different position in the two different photographs?
Do you recognize that photo?
Yes, I do.
What do you recognize that to be?
That's an additional photo of the apparent piece of hair on the rear of the vehicle.
In the two different photos, are they taken from the exact same angle?
I believe they're taken from slightly different angles.
And the hair is, could you point that out with the pointer of the hair that you found?
This here is the apparent hair.
Thank you. You can take that down, please.
No, I didn't make them for the whole class. I only had a half a bag.
Regarding the damage to the broken taillight, did you have any interest in maintaining that piece of evidence?
Yes, I did.
What did you want to do?
I wanted to collect the entire taillight housing.
Why did you want to do that?
If there were pieces from the taillight that could be later matched to the taillight, I needed the entire housing to be processed at the lab.
Did you make efforts to try to maintain or remove or preserve that entire taillight housing?
Yes, I did.
What's a taillight housing?
Excuse me?
What is a taillight housing?
I'm referring to the entire piece, including the back, the glass covering, the light bulb inside. So it's in the entire unit.
Did you attempt to remove that entire unit yourself?
I did.
Were you successful?
No, I was not.
So what did you do?
A Canton police officer that was in the Sally Port at the time offered to help disconnect it with some tools that he had.
Have you ever seen whether there's video that memorialized that entire event?
Yes, there is.
And have you ever watched that video?
Yes, I did.
Does that video show you attempting to remove the housing and then receiving assistance from somebody?
Yes.
When that housing was removed, what happened to it?
I then placed it in a box, I believe I placed it in a paper bag in a box. And then once I brought it back to the lab, I added additional cushion with additional paper to protect it from any further damage.
Were you going to keep that housing, or were you going to put that in evidence for other reasons?
That was put into evidence storage for the time being.
May I approach, Your Honor?
Yes.
Showing you a photograph. Do you recognize what's in that photograph?
Yes, I do.
What is it?
This is a photograph I took of the taillight housing back at the laboratory upon examination.
Is that in substantially the same condition as when you saw it?
Yes.
Any differences whatsoever from when you saw it?
Not that I noticed, no.
Is that photograph fair and accurate of what you saw that day?
Yes.
All right, move this photograph into evidence.
No objection, Your Honor.
Exhibit 145.
With the court's permission, I'd show photograph one, P187 to the jury. Could you, that is
That is a photo that I took.
from the vehicle,
Yes, that's correct.
and that was packaged and preserved?
Yes.
You could take that down, please. Do you have the actual item, the actual with you?
I leave it here, yes.
With the court's permission, I'd ask for the witness to be able to open the item, show it to the jury, and then move it into evidence. Box?
Yes.
May I approach?
Yes.
Do you have gloves available?
I brought gloves, yes.
You could hold that so the jury can see it. If you'd hold it up high, please. Thank you. Thank you very much. If you could return that to the box. I would move this item to evidence, please.
No objection, Your Honor.
That's the only item in that box?
There are additional items in that box as
Oh,
well.
I only want to introduce that one item.
Okay, so it's got the bag, we need to take that bag out.
There are also other items in that bag.
May I approach, Your Honor?
Yes. Yes, why don't you pull it? Actually, Paul, the lunch isn't here. It seems like time to take a break. We'll see you in about 50 minutes. Yeah,
Of course.
Okay, jurors, right this way, please. Please rise for the jury.
Okay, so 1:45. She said 50 minutes, right? It's 5 till 5. I mean 5 till 5. 5 till 1. So 50 minutes is 1:45. Let me see. Make sure.
Describe what she's doing.
See what they're doing here.
Quiet, folks, still on the record. Thank you.
Okay, I guess that's it, guys. It's 1:45. Enjoy your lunch, and I will see you all back here at 1:45 for more, everyone. And if you're not going to be able to get back, remember, you, and so do I. And if you can't be back for this afternoon, I will see you tomorrow. Have a good one, guys. Bye.